Hi, good afternoon. This is Faye Jime from Alukwanoye Bode. I'm going to be talking about setting up your business in Nigeria, the registration options open to SMEs under the Companies and Allied Matters Act 2020. Companies and Allied Matters Act 2020 is the principal law that governs companies generally in Nigeria. So when you're starting up your business, this is a law that you need to understand and you need to know the principal provisions that apply to you. I'm going to talk about the key issues that you should take cognizance of prior to setting up. I'm going to walk you through the incorporation process and things you need to know after incorporation. I'm also going to briefly discuss business-friendly provisions for SMEs in Nigeria, which were introduced under the Companies and Allied Matters Act 2020, which were not also in the previous law, that is the CAMA 1990. So there are several registration options for you under the CAMA, which is the principal law that will govern you as your small or medium-priced enterprise. You can either register as a company limited by shares, you can register as a business name, or you can register as a limited liability partnership. If you register as a private limited please, can you mute your mic? Can everybody mute their mics, please? Thank you. If you register as a private limited liability company, you would have shareholders. That is your A limited, B limited type of company. This is the most common registration option for for-profit entities in Nigeria. It is also suitable for small and medium scale businesses. There's the business name. This is a sole proprietorship form of business. Sorry, I'm not really sure where I stopped before I was muted, so I'm going. Hi, can everybody hear me? I'm not sure where I stopped before I was muted, so I'm going to go back a few slides. You can register as a private limited liability company. You can register as a business name. You could register as a limited liability partnership. For the private limited liability company, this is the most common registration option for small and medium scale business.
I'm so sorry to interrupt, Faye. Please, can everyone turn on their cameras, please? Hello, is everyone there? Could you guys please turn on your cameras? Thank you. Please proceed.
Okay, great. I tried to share my screen earlier, but it said it's not possible, but that's fine.
No problem.
Okay, the private limited liability company, that's your A limited, B limited. It's the most common registration option for for-profit entities. So your small and medium scale business. You'll have a shareholding structure. There's also the business name. This is the simplest form of CAMA registration. It's the sole proprietor form of business, and you will be personally responsible for all the affairs pertaining to the business. Then you have limited liability partnership. This was newly introduced under the CAMA 2020, although we also had a partnership law for Lagos State, but in terms of wide-scale nationwide application, this was newly introduced under the CAMA 2020, and it's suitable for partnerships that seek a separate legal, desire to have a separate legal entity. There are certain things that you should note before you set up your business. You should take cognizance of your share capital requirement. Whether are you going to do you plan on having foreign investors down the line? Do you have foreign investors at the time of setting up your company? And are there certain pre-approval or approval in principle things that you need to get from a regulator before setting up? For instance, is it a CBN regulated entity? Do you need to get CBN approval prior to starting up your business? Typically, if you want to, for people who really want to start small and they don't want the burden of having to pay companies income tax, although there's going to be a tax presentation later, I would usually recommend that you just set up a business name, and depending on how you scale and grow your business, then you can now become a company. You can now set up a company. So for the minimum share capital requirement, there's a minimum shareholding that you are required to have if you set up a private limited liability company. Under the CAMA, it's 100,000 naira. So if you're setting up your A Limited, for instance, or FAI Limited, you need to have a share capital of not less than 100,000 naira. And you need to ensure that that entire 100,000 naira is the shares are issued. The deadline, prior to this new CAMA, the 1990 CAMA allowed private companies to issue a minimum of at least 25% of their share capital at the point of incorporation. So for instance, if you had 100,000 naira as your share capital divided into 100 ordinary shares of 1 naira each, you would have been required to have allotted at least 25,000 shares to your shareholders when you're incorporating. But this has changed. You cannot have unissued shares anymore. When you're incorporating, you need to have 100,000 naira. And the deadline, companies with unissued shares must fully issue same no later than 30th June 2021. So right now, if you're setting up your business, I would advise you just issue all your shares. The only problem with this is if you have an investor down the line, or someone who wants to invest, you would have to now either divest some of the shares that you have even if you hold the shares alone, you have to give some to the shareholder, or depending on how much money the person is investing in your company, you would have to increase your share capital to accommodate that investment. I'm going to move on to the incorporation process. The incorporation process is now online. You reserve the name online, you fill all your documentation, you upload your signature, you sign it on a paper, you upload, you pay the CAC filing fees, which is 0.5 to 1% of your share capital, and you pay stamp duties, which is 0.75% of your share capital. So if it's 0.75% of 100,000 naira, that's how much you pay as stamp duty, or 0.50% of 100,000 naira, that's what you pay as filing fees. So you pay those fees, and then you get your incorporation documents. CAC will approve, and then you get your incorporation documents, and you also get CTCs. Everything is online now, so you don't have to go in physically. There has been a bit of delay. In practice, there's been a bit of delay with the CAC process, especially in light of COVID and the fact that they're trying to whittle down physical coming into the CAC. So most things are online, and they haven't gotten the hang of it. So it's a bit slow. So after you've set up, there are certain things you need to do. You need to register. If you set up a company, you need to register for your income tax, your VAT. If there are certain sector-specific registration, it depends on what sector or what type of business what type of sector your business will be operating in. You also have the Nigerian Investment Promotion Commission registration. That is if down the line you have a foreign investor. If you have a foreign investor that wants to invest in your company, then you would have to, that foreign investment needs to be registered with the NIPC in Abuja. If you have a foreign investor, your share capital cannot be less than 10 million naira. So that's the minimum. So if it's wholly Nigerian owned, just you, 100,000 naira the minimum. But if it's a if you have a foreign investor down the line, or at the start, your minimum share capital should be 10 million naira. And you'd also need to get a business permit when the foreign investor comes in. But the business permit doesn't stop you from fully operating. You can continue with your operations while you're processing your business permits. Yeah, so when you set up, there are certain, if you set up a company, for instance, if you set up a business, and it's so much easier, you don't have to go through all these, you don't have all these statutory obligations. But if you set up a company, you have to maintain a form of record, a register of the people that are your shareholders, people that are your directors, your debenture holders. When I say debenture holders, I mean, if your company, if you have a land now, and you use that land as security to get a loan, you need to register that. You need to have a record of that in your company. And it also needs, that notification needs to also be filed at the CAC. So there are certain things you need to do after post-incorporation if there's any change to your records. If you change your name, you need to notify the CAC within 15 days. If you change your directors, you need to notify CAC within 14 days. There are certain forms that you would need to fill.
Hello? Uh-oh, I think her screen is frozen. What to do?
This, I'm so sorry, I went off for a second. You have to have non-foreign shareholding for you to be a small company. So once you have a foreign investor, you're no longer a small company. And your turnover must not be more than 120 million naira. And your net assets should not be more than 60 million naira. I'm just going to go to the last piece of information. Yes, so under the newcomer, you can be the only shareholder. You can be the only director of your company. You don't need to hold annual general meetings. It's not compulsory for small companies. It can be held virtually. You don't need to appoint a company secretary, or you don't need to also have an auditor, which all these things were required before under the former CAMA, but under this new one, if you're a small company, no foreign participation, things are a bit easier for you in terms of regulatory obligations with the CAC. It's no longer mandatory for you to have a common seal. Usually when you set up before, you would have to have like a stamp that's kind of used to authenticate your documents. Now that's no longer required. Electronic signatures, if you sign electronically, your forms, your CAC forms, all these things, it's fine. Although before CAC would always want a wet ink, like a pen signature, but that's no longer required. That brings me to the end. I hope I have been able to cover everything, but yeah, doing a question and answer session. Okay, thank you.
Thank you. So I think the next person is sorry, which of you is from? Oh yeah, I think Eustace is next. He's supposed to be talking about setting up a tech company and data protection.
Yeah, thank you for that, Kenny. Can you hear me?
Yes, we can.
Okay. All right, let me share my screen a bit. Okay, so I think I'm having problem sharing my screen. So we'll just, I'll just move on with that. Yes, setting up your tech company. So there are 5 basic things I feel you should consider when setting up your tech company. So first is your structure. The second, your contracts, put your contracts in place, your intellectual property, your incentives, and specific licensing. So after we talk about this, we'll double directly into data protection. So the first is your structure. So when considering the structure, you would also have to consider what is effective for you. As said by the earlier speaker, there are several structures under the corporate law of Nigeria. We have the business name, private limited, private company limited by shares, public company limited by shares, and the limited liability partnership introduced by the new CAMA. So you have to consider what is effective for you. Consider your sector-specific laws. If you're entering a sector, some sectors it's mandated that you are registered as a company, and you cannot enter the sector as a business name. So things like that, you have to consider them. You have to consider your tax implication and investment and loans. So now, in setting up, most times a business name can appear to be preferred. Sometimes it's a company. So for a company, it's because if you register as a company, you've created an advantage of receiving equity investments from your investors. So subsequently, when your business you intend to receive investments from your businesses from other investors. Sorry. So at that point, you have positioned yourself to receive equity investments, and which will not be available for you if you have registered as a business name. And also, for some banks, some banks require that you are incorporated as a company and not a business name. So you may also have that problem in obtaining bank loans if you are registered as a business name, not as a company. So generally, company limited by shares is generally preferred because of it's a lesser obligations than a public company, of course.
So sorry to interrupt, Eustace. Could you try sharing your screen again?
Okay. Okay. So can everyone see my screen? I think it's... So can you see my screen now? Hello?
Yes, we can.
Yes, we can. We can.
Okay, thank you. Okay, so as said by the earlier speaker, the CAMA 2020 introduced the one-man company. So one person, prior to this dispensation, in the old law, if you have an idea of a tech company, you have to look for a partner to partner with. So if you have an idea, you have to probably find someone to attach yourself with so you can incorporate a company. But under the new CAMA, you can open a one-man company, be the only shareholder, only director, which is a great advantage. So he also introduced the limited liability partnership that combines the corporate status of a company and flexibility of a partnership. So the CSC, that the Corporate Affairs Commission, does not currently register this LLP on its portal, but we envisage that in recent times it would commence that soon. So I will jump the minimum share capital because I know the first speaker spoke on that. I would go straight to your contracts. Now, in setting up your tech company, we believe that you should also put your contracts in place. Why is this? This would regulate your relationship with your company. This doesn't matter if you are the only shareholder or you are the only director. It helps to have your contracts in place to regulate you, to protect you and your business, and it also attracts investors. So whether it's your shareholder agreement or your finance agreement, it will regulate the agreement between all the shareholders of the company. Your non-disclosure agreements for where you are sharing your confidential information with the contractors and service providers. Now, for loan agreements, it's also common for persons to grant loans to their companies at the inception with the idea that they would obtain the amounts back subsequently when the company is big and has enough. But it's important that at this point you enter into a loan agreement with your company. And if you want shares in place of the loan, you enter into a compatible loan agreement. So this is important because most times when you get an investor, especially foreign investors, they may require that you revest your shares because they do not believe you have made any financial input in the business. So at this point, it is very important that you enter into your contracts to prove as a source of evidence to your inputs into your business. So also, we also advise that we understand that for tech companies, you may not have the necessary financial ability to pay for the skilled staffs that you require. So for key staffs, we also advise you have an employee stock option, which grants your employees shares in addition to their financial wages. So it grants them some percentage of shares, which will vest within a period of time in addition to their financial wages, some form of incentive to your key employees to make them, I say, work better. So we'll move next to protecting your intellectual property. So it is protecting your creation. It is very important at this point that you, when setting up your tech company, that you ensure your business, your intellectual property is protected. In the long run, when you want to, in the long run, when you intend accepting investors or selling your company, the goodwill, the intellectual property will go a long way in the valuation of your business. So at this point, we always advise that you make sure your intellectual property are protected, whether it's your name or your logo or things like that. Because generally, as your business grows, you also aspire that your goodwill grows. So when they see your sign or your name, they believe that it stands for something. So literary works, musical works, artistic and cinematography, computer programs, all these are protected under copyright. So copyright protects it automatically. You don't have to go and register, but you can be proactive, and there's an online platform for you to register your copyright creations. So you can register it online, though it is protected upon creation, but it's also advisable that you register it online. We have the trademark. You can trademark your logos and your name. So patents. So for unlike the copyright, the patent is for when you have created something new, or yes, when you created something new, it protects the method and process used in developing the creation. So when you have a new software that has qualified, because patent has some criteria you have to meet up with. If it qualifies for under those criteria, then it will be protected for a period of I think 20 years. So the method and the process used in creating the software are also protected, unlike under copyright. So we also have designs. What the example that generally comes to mind under designs is the legendary Coca-Cola bottle. So when you have a design that is unique, so you can have it registered under designs. You can also have your non-disclosure agreements to protect your confidential information when you share them with service providers and contractors. So incentives. So you also have to note your incentives. So I won't speak so much on this because we have someone who will speak on tax later. So, but under the Finance Act 2019, small companies were exempted from paying tax. That's companies that their turnover are lesser than 25 million. And then medium companies are to pay 20% tax instead of the average, the usual 30% tax. So under the Finance Act 2020, then small companies are permitted from paying tertiary education tax. So you should also note general incentives that apply to you to ensure you don't pay needlessly for taxes that do not apply to you. So another aspect you consider is sector-specific licensing. So if you're entering into the financial sector, you know that generally the Central Bank of Nigeria will regulate your generally regulate your business. So if you are going to be a mobile money operator, a payment service provider, we have cases of individuals coming to say that they have created an app that does a payment service or that creates some sort of savings. So if depending on the sector you fall in, you should also note your regulators. If it's a payment service provider, finance company, or a mobile money operator, you would have to require the license from the Central Bank of Nigeria. You're going to be doing crowdfunding like crowdfunding investments or cryptocurrency. Securities and Exchange Commission would be your regulator. So generally, for loan companies, you have to seek license of the Lagos State Ministry of Home Affairs. For best companies, a lottery. So generally, so on and so forth. One of the common regulator that you would have cause to interact with would be the National Information Technology Development Agency. That's NITDA. So for companies that have personal information of Nigerians or e-commerce businesses or service providers, you have to interact with the NITDA. We'll speak more on that when we get to the data protection aspect. So there are other general regulators like the local government, SCOMO, and the LASA, that's the Lagos State Signage and Advertising Agency. So now, this is general data protection. So most times, when you say data protection, most people don't understand the extent of it.
I think we're having network problems again. Eustace, are you back?
Yes, I'm back. Sorry for the break. So trying to share my screen again. Yes. So yes. So they said the experience economy. Customers like to feel that you know them. So I'll give an example. One of the first times I used an automatic an ATM machine of a different financial institution, different from my own financial institution. When I inserted my card, I saw "Hello Eustace." I saw my name. I was not impressed, but I noticed. So generally, what James and Joseph were trying to say is that when you feel when customers feel that their service providers or their the business owners know them, they may not be impressed, but they'll notice. So we might not actually be impressed in quotation, but we notice it. So that was the whole idea of the experience economy. So this can only be achieved through the help of data. So it is only when the innovations and how to simplify things can only happen through the processing of data. Data is the key to everything, and data provides better ideas of how to make businesses better. So I give you an example. For if you search generally on your phone, on any browser on your phone, where to purchase furniture, and you have an Instagram application on your phone, mobile application on your phone. Once you open your mobile application, you generally start seeing ads on the application on furniture sellers. It's just like that. So things like that, it creates some form of fear. Should I say the word fear? Yes, and people become conscious of how did you know I just did this. So data helps in marketing, but then again, it comes back and it's delicate. We have to use it with caution. So companies need to know what is acceptable and what is not acceptable, what you can do with data and what you cannot do with data. So I give an example of earlier this year, Facebook and those WhatsApp updated the mobile application WhatsApp, the instant messaging application WhatsApp. updated its privacy policy and stated that, and most people that read the privacy policy understood that if your messages, your private messages with your contacts will be shared with Facebook. So because of that, a lot of people boycotted WhatsApp, which then WhatsApp had to come up later on to debunk the idea that they don't share personal information. So at this point, you need to know what you can do with data when you have it. No matter, even if you're not doing such great, you're not processing it in large scale as some companies may do, like at WhatsApp and major companies may do. But if you have personal data and you save them, you need to know what you need to do with them. So over the next few slides, we'll be taking you through what is expected of you. So the next is the risk associated with data usage. So identity theft and fraud. So I was directing one of my colleagues and I was informed that a lot of Nigerian personal information are for sale on the dark web. And this is a bit frightening because, and this arises as a result of the breach of data on the part of companies in Nigeria and outside Nigeria handling the personal information of Nigerians. So we have credit card counterfeiting, nuisance. So a lot of times you receive spam emails from persons asking you to give them your financial information. This is as a result of maybe where you have dropped your email addresses and you have access to it. So things like this are risks associated with dealing data usage. So we also have the manipulation. You should, generally, I think 2 years ago, Facebook had this issue of where they were fined with 5 billion by the US government and 500,000 pounds by the UK government for allowing an application harvest the information of Facebook users from its app. So these are general risks associated with using data. So what do we have in place? What has Nigeria got to protect ourselves? So generally, first, we have the Constitution, our right to privacy under Section 37 of the Constitution. So that does not seem like much. So we also have the Nigerian Data Protection Regulation, which was issued by NITDA. Yes. So in 2019. So the NDPR, the Nigerian Data Protection Regulation, I'll be calling the NDPR. The NDPR protects Nigerians everywhere, both in Nigeria and abroad, and persons resident in Nigeria. And companies that deal with data of Nigerians, whether in Nigeria or abroad, are to comply with the provisions of the NDPR. So the aim is to ensure that the privacy of Nigerian citizens are protected. And when you fail to comply with provisions of the NDPR, you may be subjected to a fine of 2% of the annual global turnover or 10 million naira, whichever is greater. So this does not include your any civil claim or any criminal prosecution that might follow from the breach. So before we go further, I would also like to explain the key terms. So personal data, what do I mean by personal data? Personal data are any information relating to an individual that can be used directly or indirectly to identify that person. So for instance, let me give you an example. My name is Eustace Arrow, and it's some sort of a unique name. So I think if you Google the name Eustace Arrow, not many names would come out as Eustace Arrow. So you can directly use it to identify me. So when you Google Eustace Arrow, you can directly get that this is the person I'm talking about, most likely. There's some other unique, very uncommon names, let me not say very uncommon names. But let's say you have my address now. I live in 5 Coconut Island. So I might not be the only one living in 5 Coconut Island. I have my family, I have my neighbors there. So that if you have 5 Coconut Island and you have my email address, then you can find out I work at Pavestones Legal and go to 5 Coconut Island and look for who works at Pavestones Legal. By then, indirectly, my address that you have has been able to link you to me. So that is personal data. When you have an information that can alone link you to a person or with the help of other information, link you to the person that you are looking for. So general examples, we have the name, address, phone numbers, date of birth, birthplace, your picture, your email address, personal information, financial information, general geographical information, all that. So due to the due to the advent of internet and all that, we also have the social media IP address, metadata, MAC address, IMEI numbers, MISI as part of your personal information. So also have the data controller. So a data controller is anybody who determines the purpose and the manner in which any personal data is to be processed. Now, so I'll give you an example. I want to create a document, I want to create a parcel to Abuja. So I meet up with company A and I say, I need to create this document to Abuja. And I fill up my information. Company A does not have dispatch riders within Lagos to pick up the package and take it to their transport address. So company A is just probably a transport company that's shuffled between Lagos and Abuja, but they don't have dispatch riders. So company A goes and meets company B and asks that, okay, we need you to help us pick up this package and bring it to our address so we can send it to Abuja. So company A is the one who I give my data to. Company A has determined how, and of course, company A will have to share my address with company B. So company A has determined how company B will use my address. So in that context, company A is now a data controller because they control how the data is going to be used. Yeah, so in that scenario I just gave, company B would be the data processor because they have been given a task to do. So they are now to process the data on behalf of company A. I don't care whether the company A has a dispatch riders in Lagos. All I know is that they can send my document from my house to Abuja. So if they're going to meet with any company, that is not my business. So company B is doing that in place of company A. So when I see company B come to my address and say they want to pick up this packet, I assume they are working for company A. So the fact that it's a different company doesn't matter. So company B in that scenario is a data processor, and they're processing my data that is coming to my address to pick up a package on behalf of company A. So they are data processors in that instance. So we have data subject, which are me and you, that give our personal data to companies. So there are generally 6 principles of the NDPR that we have to comply with. So we'll briefly run through entire 6 of them. So the first is lawfulness, transparency, and fairness. So data protection, data collection and processing must not breach the law. So what is the legal base? The legal basis of collection and processing, we shall discuss that in the next slide. But generally, you should know that in collecting and processing data, you must always do that in compliance with the law. So you must disclose all the purpose for which your data is collected for. So I give you an instance now. I make a game, and you come to purchase my game from me, and I tell you I need your details, your contact details. Now, I must tell you if I want to use your contact details to support you in installation of the game alone, I must state that categorically. That's all I'm going to do. But if I'm also going to use your contact information to advertise and to sell other patches or upgrades of the game to you, I should also state that to you. So all the purpose for which I'm collecting your data, I must state it categorically to you. So if I'm going to use the data, if I have told you I'll collect your data only to support you in installation of the game, and I subsequently noticed that, oh, I feel I should also sell my upgrades to you. Before I can use the data for that purpose, I must seek your consent. So I must come to you and say, oh, I have the data for this, and this is what I told you I want to use it for. But I also need to do this. Can I use your data for that? So you cannot collect for a purpose and use it for a different purpose. That's the points we're trying to make there. So the next one is accuracy. You have to ensure that your data is accurate. So people like me that have a feminine voice, so you speak to me on the phone and you record that Eustace R is a female because you had my female voice. That data is not in its entirety correct. So it is your obligation as the data controller to ensure that the data is correct. So if you cannot come and say what you have in your record is female, even if it was given to you, should ensure that your data is correct at all times. So data subjects have the right to ask for your data to be rectified, and you should rectify within at least 30 days. We have a storage limitation. So if you're keeping, a lot of companies are guilty of this, so they keep data ad infinitum. So you go to a place and they ask you to fill your name before you enter a building, and you fill your name. And this company has been piling the register of all the visitors they have had since 1990, and just keep storing them somewhere and storing them somewhere. So this principle is saying that you have to only, you can only keep it for the length of time that's required. So if you only need it for 6 months, just keep it for 6 months. After 6 months, you destroy it or archive your data. But in doing this, you have to also consider your sector-specific duration. So some sectors require you to keep data for a period of time. So you also consider that when determining your storage duration. So we also have data security and data minimization. You have to ensure that data you collect are protected, encrypted, pseudonymized. It is your obligation as the data controller. Then data minimization is you have to ensure that you only take as much data as you require. So if you only need my name, take only my name. There's no need to take my email address, phone number, father's phone number, and all that. If all you need is my name, then you should limit your data collection to just my name. And we have the accountability. You are required as, this generally applies to data controllers and data processors. So generally, first you have the obligation of ensuring that you comply with the NDPR, and you have to show that you comply with the NDPR. So if I comply with the NDPR and I cannot show that I comply with it, I can't say I have complied. So if you're complying, you must be able to also show that you have complied. Next, you are responsible for the compliance of third parties. So if the example I gave before, I meet a company to courier a parcel to Abuja, and the company A goes to meet company B and tell company B, help me to go and pick up the package. And they give company B my address. If company B misplaces my address or is careless with my address and anything happens, I can hold company A. I do not know company B. I go straight to company A, I give my address to you. So company A will be responsible and accountable for whatever company B does. So the next is confidentiality. You have the obligation of maintaining the privacy of the data you have collected. So next is the legal basis, as I said. What is legal basis? When processing data, you have to consider for the legality for which you are processing it for. At every point in time, you are collecting and processing the data. You have to know what is my legal justification for doing this. The most common one is consent. You have a consent of Mr. A to process the data. So generally, it's the most common legal basis. So it's generally used and it's also the safest legal basis. We also have public interest. So if I am processing your information to, if I have your data and I need to process it to prevent fraud or to comply with any public policy, then I can say to have come on that. I can process your data with public interest without asking for your consent. So another example is contractual necessity. So you enter a contract with me to prepare a furniture, and subsequently we agree that you shall deliver the furniture to my house. You already have my house address. So if by that you process the data, that is, you give the furniture to someone to deliver to my house, that is by you processing my data. I cannot complain because it is needed by the terms of our engagement. I have engaged you to deliver it to my house. So if you then use my address to get it to my house, then I cannot complain because it is necessitated by what we have stated in the contract. Another is legal obligations. So for some companies are mandated to process data for some legal obligations, maybe mandated to disclose information to law enforcement agencies and things like that. But that you can do that without having recourse to the data subject. So if you have my personal data and I am wanted for and are being investigated for something, and the law enforcement agency comes to you requesting my personal information, and you're under legal obligations to give to them. You do not have to have recourse to me before you can give them the personal information. The next one is vital interest. This usually relates to matters of life and death. So if processing my personal information would probably save my life, then I think you would have. I think you can. Vital interest is one of the legal basis for you processing my data. So the last is legitimate interest. It makes it one of the trickiest of the legal basis. Has been subjected to several arguments and debates. So it's basically what is legitimate to either the controller or you, the data subject. So if at some point you are going to process my data if you take some information with your cookies to ensure I do not defraud you, at that point you can come under legitimate interest to process my data without having consent. So generally, what we're trying to say is that at every time you are using personal data, you must ensure it falls into at least one of this. If most likely consent is the first call, or if you cannot obtain consent, then you should ensure it falls under one of these legal bases. So we'll do a little explanation of what we mean by consent. So you are mandated that if you're asking for consent, that you obtain the consent from the data subject freely without undue influence. The consent must be explicit and must not be bundled, but not say, okay, give me consent to do A, B, C, D, E, F. So you have to space it out. Okay, you give me consent to do this, you give me consent to do this. It must not be all bundled up to create confusion to the data subject. The consent must be recorded. This is a general problem of company because they have no way of showing that, okay, this person consented to it. So it's usually better if you have a box for you to tick that, okay, I tick this box because I consent to it. So just me giving my information does not necessarily mean I consent. You should also provide a box so you can show that I consented. So consent must be recorded. That is the way for you to record that, yes, I consented to share my information with you. So if you can have a box, if you have a website, you can have a box on it and say, okay, tick this box to show it I consent to this thing. Put a box there for the user to tick. So by ticking you have recorded that he has consented. So then by then you comply. But generally, if it comes to data direct marketing, to some countries that are not on the whitelist, you generally must seek consent. But for those purposes, you have to seek consent of the data subjects. So I would try and finish up very quickly. Time is fast spent. So privacy policy, there are general things that you are required to put in your privacy policy. So the basis for which you are collecting data, why are you collecting it? On which basis are you collecting it? Is it to do, what are you collecting it for? The type of data you're collecting, is it just the name, email address, or is there a cookie somewhere that collects my IP address and all that? So you have to state that in your privacy policy. So the purpose for which you are collecting it. How is the data collected? Is the cookie collected by me logging in? Is it when I give my data to you? Or is there somehow you collect it without me knowing? You have to state all this. And the data must be stored, must be processed. How is processed and stored? You have to state that. It's who you transfer your data to. So at some instance, you might have to transfer data to a third party that is not your company. So you have to state that also in your privacy policy. How is the data protected? Is it by encryption and all that? You have to state that. How long do you keep your data? The data subject's rights and how you can exercise its rights. Now, the last one is one that generally not most companies forget to include is remedies to when company fail to comply with data privacy. So if I have data privacy and I do not comply with it, I have to state in my data privacy that, okay, this is my data privacy. If I do not comply with this, this is the remedy you can seek. Yes. So and the time frame for me to grant the remedy to you. So you have to also state that just putting that you will desist. If you put a clause that says you will desist from the wrongful use of the data, I think that would suffice. So at this point, it's also necessary for me to state that privacy policy is not the same as a data protection policy. Data protection policy are policies um, that your data subject should generally know, includes things the data should generally know, like your address of the contact information of your DPO, that's the data processing, your data protection officer, and all that. But I think most times you can just lump your privacy policy and your data protection policy together, and I think you will be fine. So rights of data subjects. So there are a number of rights of data subjects. You as a business owner should know this. So you know how to ensure that you respect the rights of data subjects to avoid being penalized. So data subjects have the right to access their personal data. So at any point they can access the data they have in your custody for free. So you have to respond within 30 days. So only when the request is becoming annoying or continuous, then can you refuse granting access. So if asked, for instance, now Mr. A asks for his data, for the personal information I have of him on Tuesday this week. That's yesterday. Asked yesterday. Then he comes next week Tuesday and asks for the same information. I can just ignore. At that point, it is becoming repeatedly, and it will affect. It is consuming time. Yes, business time. So at that point, you can just notify him that nothing has changed or refuse access to his data since nothing has changed. You also have the right to be forgotten. A data subject can ask you to delete his rights. Delete his personal information. So it can ask you to restrict processing, that you shouldn't do this with the data, you shouldn't do this with data. They have the right to do that. They also have the right to withdraw their consent. So if I'm giving you a consent, I can tell you, okay, I withdraw my consent. Don't process it again. I'm not giving you consent for it again, and I need my rights to do so. So we have the rights, they have the right not to be profiled, and they have the right to ask for their data to be ported. So the data to be ported is by asking, okay, I bank in Bank A and I want Bank B to receive my personal information. So I tell Bank A, send my personal information to Bank B. I have a right to do that. And Bank A is mandated to comply with that. So the next is data protection officer. So generally, companies are expected to have a data protection officer. The idea is for you to have someone who ensures that you comply with the provisions of the NDPR. So this person will be answerable to NIDA. So when NIDA comes around and knocks on your door, your DPO should respond and like, okay, and provide them with the information that they require. So the DPO also has the obligation to report any security breach to NIDA and to data subjects. To NIDA within 72 hours and data subjects within reasonable time. So estimate that at least within a week or two. So the DPO should also maintain the records of data processing. So all the things you do with data, the DPO should have a record for it. Okay, we use data to do this, we use data to do this. So the DPO should maintain a record for that. The DPO should also have organized data protection impact assessment. This is a way to assess the risk of processing a particular information. So if I'm going to use this information, if I'm going to use, okay, for instance now, we bring we are a tech company and we have personal information on our laptops, and we bring a policy and say, okay, everybody can take their personal information, their laptops home that contains personal information. The DPO at that point is expected to do a data protection impact assessment to assess the risk associated with you taking your laptop home. At that point, what is the risk attached to that? So that is the job of the DPO, to assess the risk and determine whether to move on with the processing or not. So, but having a DPO is generally not mandatory, except you have data of over 10,000, a government agency. You have sensitive data. Sensitive data involves medical information, ethnicity, health, sexual orientation, political orientation, and things like that. And whether if you have a national information, physical national information, then you must have a DPO. Other than that, you don't have. You are not mandated to have a DPO, so to say. So a DPCO. So DPCOs are generally licensed organizations by NITA. Here's something else, are also licensed DPCOs. Are licensed to audit companies. They identify gaps, help you meet up with the requirements of the NDPR generally. So for companies that have data of over 2,000, you are expected to conduct audits within a year and submit before the 15th of March. But if you have 10,000 data subject, then within 6 months, you have to conduct the desktop audit and file the copy with the authorities. So that is all for setting up your tech company and data protection. Thank you.
Am I to go next?
Actually, I was just checking a message from the chat. I'm actually supposed to go next, but if you're ready, that's fine. You can go ahead.
Okay. All right, thank you.
No problem.
Good afternoon, everyone. Thank you to the Public Interest Law Partnership Office for this opportunity. And I also thank all the panelists that have spoken before me. My name is Toyosi Alasi from Banwa and Gudalu, and I'll be speaking on tax considerations for SMEs under Nigerian law. Now, a lot of the conversations that we see around taxes are usually centered on, the big companies, the multinational
companies. We can't see you.
Sorry, I had turned off my camera because my internet is fluctuating.
Oh, your network is bad. Okay, no problem. Go ahead.
Can I have permission to share my screen? I think it would be easier that way. Can the host give me permission to share my screen, please? Thank you. Can you see my screen now?
Yes.
Okay. Okay, so I was saying that a lot of the conversations that we see online and generally in the public domain are usually centered around the tax considerations for the multinational companies, the IOCs, and essentially the big companies. And very little attention or very little literature is available in relation to SMEs. And sometimes it can give SMEs a false sense of the fact that maybe they don't have tax obligations, or there are no expectations in relation to what taxes they are supposed to be paying. And in some cases, of course, the government also doesn't even really go after the small companies. However, all of that appears to have changed in recent times, particularly now that the government is looking aggressively for alternative sources for funding its operations and deficit in the budget. So now more than ever before, we see that the tax authorities are going after everybody, that's SMEs inclusive. So it's very important now more than ever for SMEs to also ensure that they are complying with their tax obligations as laid down under the law. I'll quickly give us a few, let me say, statistics, just to help us put things in perspective. So the International Finance Corporation did a survey, and from their survey, they found out that SMEs represent about 90% of businesses and more than 50% of employment worldwide. The study also showed that about 96% of Nigerian businesses are SMEs. That's in comparison to about 53% in the US and 65% in Europe. Now, what they also found out is that the SMEs in Nigeria only contribute about 1% of GDP, to our GDP, compared to 40% in Asian countries and then 50% in the US or Europe. So this just helps us put in perspective how that even though SMEs constitute 90% of businesses, a lot of SMEs are not paying taxes to the tax authorities. And of course, if you're going to build a sustainable business, and you don't want to see it collapse under the weight of legal liabilities that may come from not having complied with the tax obligations as laid down by law, then it's also important that compliance should be prioritized by SMEs. You should take steps to ensure that you're complying with all of your tax obligations. As it is with every other law, ignorance is not an excuse. So the fact that an SME owner does not have information or didn't know that certain taxes are applicable will not take away the obligation to pay those taxes. So it's important to ensure that you get sufficient information on the taxes which are applicable. And in this session, I'll just try to take us through some of those taxes. Given time constraints and considering the fact that the topic tax or taxation is a very wide subject, I'm not sure that we'll be able to cover everything in this session, but I'll just give us an overview of the taxes which are applicable to SMEs under Nigerian law. But first, I think we need to define what taxes are. So taxes are compulsory financial levy or charge imposed on citizens by the company or by the government, sorry. What is most important about taxes is the fact that it's a compulsory obligation. It's not something that is voluntary. So companies are not allowed to pick and choose which taxes they're going to be paying. They have to pay the taxes as have been mandated by law. Sorry, excuse me. So, of course, I've said that taxes are usually imposed by an enactment of law, which means that there are laws backing up the taxes which companies are required to pay, in carrying out their operations in Nigeria. As we go to consider some of those taxes, we'll see the relevant laws that has mandated the payment of the relevant taxes. So again, we need to note that it's something that is compulsory, it's not voluntary, it's a levy, it's imposed, and is usually enforced by a government, which is why the tax authorities will come after defaulters. Again, because tax constitutes a huge source from which the government funds its activities. So broadly speaking, taxes can be categorized into income taxes and transactional taxes. And we'll go on to consider what those are. So income taxes are taxes imposed by the government on the income or revenue of individuals or businesses. So this would typically be the taxes which be applicable to the gains, the profits which an individual or a business has realized in the course of carrying on its business. Examples of income taxes, of course, are company income tax, personal income tax, the petroleum profit tax, and education tax is also one of the income taxes. On the other hand, transactional taxes are taxes which apply to transactions. So it doesn't really matter whether or not a company is making profit. That's not the focus of a transactional tax. The important thing is that a transaction which attracts a tax has been undertaken. And so the company would have an obligation, the company will have an obligation to pay applicable taxes relating to that transaction. So if it's a sale transaction, if it's a purchase, it's in relation to payments which are made, there are taxes which they attract. And very quickly, we'll also go ahead to consider some examples of transactional taxes. So transactional taxes would be value-added tax, stamp duties, withholding tax, capital gains tax, import duties. These are just some of the examples of the transactional taxes. We would still go ahead to consider these taxes in a bit more detail or in fuller details as we go on in the course of this session. So what we need to know about companies' income tax. Of course, companies' income tax is the foremost tax that all companies are required to pay, except maybe for those companies which are operating in the petroleum industry or the upstream of the petroleum industry. They have a separate type of tax which is applicable, and that's the petroleum profit tax. We'll also come to that in a bit. So the company's income tax, of course, the basis of the tax is the Company Income Tax Act and the Finance Act, which has generally introduced amendments to virtually all the regulations that border on taxes in Nigeria. So when we say, applicable law, let's just take it as a given that the Finance Act, is applicable in all cases. So the CIT is calculated essentially based on the taxable profits which a company has realized in a financial year. And I'll give us some of the examples of income which may have been realized by a company which will be liable to companies' income tax. So any profit accruing in, derived from, brought into, or received in Nigeria, irrespective of trade or business, is liable to CIT. I'll just simply call it CIT. And of course, this is understandable because every Nigerian resident company is liable to income tax on its worldwide income. So it doesn't matter that the company is carrying on businesses outside of Nigeria. Whatever profits are being realized from such ventures are also liable to companies' income tax under the Nigerian law. Another example of an income that will be subject to CIT would be dividends or even rent. So a company gives out a property, rent is paid on that property. From the rent that is paid, CIT is chargeable on that property. Another example would be fees. So a company provides a service to a client and earns fees. The fees that have been paid, are liable to CIT. And then also dues or maybe allowances that are paid for services rendered by the company would also be chargeable to CIT. Again, profits and gains from maybe acquiring and disposal of short-term money instruments. I'm talking about maybe a company has acquired some government securities, for instance. You have treasury bills, you have savings certificates or debenture certificates. On all of these assets, income tax, companies' income tax will be chargeable. And as I rightly said there, of course, it's the FIRS that administers the CIT. Also, I would also give some examples of certain allowable deductions or expenses or income which are expressly exempted from companies' income tax. An example that comes to mind will be interests on government bonds. So you subscribe to a government bond, you realize interest in relation to that subscription. That interest is not liable to companies' income tax. Or if you realize interest from a foreign currency domiciliary account, or let's even say maybe stock dividends, bonus shares, all those are exempted from CIT. And then it's also important to note that certain SMEs may, by virtue of how they have been organized, in terms of the sort of legal entity that has been set up, may also be exempted totally from companies' income tax. So an example would be a company, what we commonly note and describe as a company limited by guarantee, which are companies which are set up not for profit purposes, but to provide some charitable service. You know, if the services that they are providing are not with the intent to earn profit, then their activities will not fall under the categorization of companies which are liable to CIT. However, if they carry on business, in the course of their existence, that business, whatever profit is realized from that specific business, would be liable to CIT. An example of another company that will be totally exempted from companies' income tax would be, a company that is set up to operate within a free trade zone or an export processing zone. The income realized from those companies would be exempted from companies' income tax. Another example would be a small company, and I think that Eustace mentioned this when he was making his presentation. I don't know if he was Fei that mentioned it, that for small companies are defined under the Finance Act as companies with turnover of less than 25 million. So if as an SME, your turnover in a year is less than 25 million, you're completely exempted from filing, you're exempted from CIT. However, let me preempt myself and also say that the fact that a small company is exempted from CIT does not mean that it shouldn't live up to the expectations under law in terms of the reporting that it is required to do, registration for CIT, and also filing of the returns which are required. So even though it's a small company, for whatever reason, it doesn't file the applicable returns within the statutorily stipulated timelines, that company will be liable to penalties and interest, irrespective of the fact that it's a small company. So it's important for SMEs to also take cognizance of that if you fall under the category of a small company. Another example of a company that will be exempted from companies' income tax are companies which are carrying on business in agricultural production. But this is not an absolute exemption, it's just for a period of time. So for the first 5 years, the company will not be liable to CIT, and the period can even be extended, of course, further to an application by the company. If the authorities consider that the company has performed satisfactorily well, they can grant a further extension for 3 years, within which the company will not be required to pay any CIT. Now, prior to the passage of the Finance Act, what we had was a flat rate of 30%, which was the applicable CIT rate for all companies carrying on businesses. However, in a bid to make the business environment a bit more conducive for SMEs, and also to encourage SMEs, to grow their businesses and all, the Finance Act introduced a scaled, rate for computing how much CIT is to be paid in relation to the profit of the company. Now, for small companies, and I've defined small companies before now, those are companies with annual turnover of 25 million or less. They are completely exempted from paying CIT. For medium-sized companies, those are companies who have annual turnover of between 25 and 100 million. they are paying a reduced rate of 20%. And then for large companies, these are, of course, companies which are not small or medium companies who have turnover of 100 million and above, they are required to pay the rate of 30% of CIT on their profit. Now we move to personal income tax. I'm sure a lot of us are familiar with this. This is essentially a tax that is imposed on individuals who are either in employment or running their own businesses or both. So if you are an employee working under someone, you're liable to personal income tax. If you're, let's say, a petty trader or you own your own business, you are also still liable to personal income tax. And we even have cases of people who have a regular day job, but then still have a business on the side that they manage. They are liable to personal income tax on the income earned from both sources. So either it's from the formal employment or from the businesses that they've set up. They are liable to pay personal income tax on the income realized from those ventures. So Personal Income Tax Act, of course, together with the Finance Act, regulates personal income tax. Usually, personal income tax is payable to the state tax authority. Again, because residency is the basis for determining tax in relation to persons, or let's say even businesses that are not organized as a corporate entity, let's say a business name. Residency will be the basis for determining where you're supposed to pay the tax to. So for instance, if you're in Abuja, the tax that you'll be paying as an individual or that your employer will be paying on your behalf will be paid to the Inland Revenue Service, FCT. If it's Lagos, then of course you pay to the Lagos Inland Revenue Service. I said it's important to note that employers have the obligation to deduct applicable taxes. Now, as it relates to employees, those taxes are to be deducted at source, which means that they don't even come into the hands, or they are not supposed to come into the hands of the employee. So the obligation is on the employer to ensure that applicable taxes for employees are deducted and then remitted to the appropriate tax authority within stipulated timelines. If, for whatever reason, the employer fails to do that, then the employer will be liable to penalties and interest, which will be levied on the employer by the relevant tax authority. Now, personal income tax is essentially charged on the income of individuals on a graduated scale. There's a consolidated relief allowance of 200,000 plus 20% of gross income, subject to a minimum tax of 1% of gross income, whichever is higher. Now, this may sound like gibberish and it may be a bit difficult to break down given our timing, but what I would just like to say is that there are a lot of applications online now that make it easier for you to be able to determine what is the applicable rate for a certain cadre of employee, based on the salary that the employee earns. There are all sorts of apps online that can even help you calculate how much it will come to once you plug in the figures. So I don't think we need to bother ourselves too much on that. But maybe what I will just say is that, and I'll move to the next slide, is to show the graduated scale, the table of how the personal income tax is being calculated. So for the first 300,000 is 7%, and it goes all the way up to 24%. Depending on the amount of the employee's monthly emolument. Now, an employer, of course, is required to file the appropriate personal income tax returns. It's what they usually call it Form H1, for those who are familiar with the form. And that form would usually show the summary of income earned by the employees and the personal income tax deducted for each of the employees. Now, if for whatever reason the employer fails to file the return within applicable timelines, this is actually a criminal offense. It's criminalized under the Personal Income Tax Act, and upon conviction, the employer may be liable to a penalty of about 500,000. So it's important that employers ensure that they are familiar with the process of remitting their taxes, their personal income taxes on behalf of their employees, the timelines applicable for doing such to ensure that they are always in compliance with the provisions of the law. Later in the course of the presentation, I'll still get to applicable timelines for some of these obligations, so as to make it easier for us to know the applicable timelines. So, what income are chargeable to tax under the personal income tax? First is the employment income. So salaries, emoluments, which are payable to the employee, are chargeable to personal income tax. Then if you are a sole trader, self-employed, unincorporated entity, of course, you are expected to go through the direct assessment, which is that without any demand notice from the tax authorities, you declare how much profit you have made or how much income you have realized in the course of a financial year, and you file your returns with the tax authorities accordingly. Of course, partnership as well, like I mentioned, if you're in a partnership and you have realized certain profit from that partnership, you are expected to go through direct assessment to file your tax returns. Investment income. So let's say you have interest income, dividends, rental income, like I mentioned earlier, or royalties or director's fee. If you sit on the board of a company where you're being paid director's fees, all those fees are chargeable to personal income tax. And in appropriate cases are also chargeable to withholding tax. Withholding tax will be, of course, if you have provided a service, there's the law requires, and we'll still come to withholding tax and speak more on that. The law requires that you withhold a certain portion of that money and then remit to the relevant tax authority. So settlement, estates, and trust income, if you have a trust arrangement, whatever profit you realize from that arrangement is chargeable to PIT. If there's an estate, so an estate is being administered further to a will, the beneficiaries of that estate, whatever profits are realized are also chargeable to personal income tax. Essentially, any form of income, so income made by individuals, committees, or families, are all chargeable to personal income tax. And the relevant, the individuals are expected to ensure, if they are not under a formal setting where they are employed, if they are self-employed, they are to ensure that the relevant returns are filed as and when due. So we'll move to the next tax, which is the tertiary education tax. This is a tax that has been imposed by law and is accessible profit of the company is at 2% from the accessible profit of the company, and it is applicable to all companies registered in Nigeria. Of course, the appropriate authority to enforce that is the FIRS, and that's the entity to which the taxes are also remitted. So usually what you will have is that you get a demand, a notice in relation to this tax, and you are expected to pay the tax within 2 months of receipt of the notice. But what most companies do, they don't even wait for the notice. They just pay the tax on a self-assessment basis along with the company's income tax. So when they're paying the company's income tax, they also just pay the tertiary education tax as well. For companies that are subject to petroleum profit tax, as we will soon come to discuss, the tertiary education tax would be considered an allowable deduction, which means that they will be able to net it off, what will be their ultimate tax liability for purpose of determining their taxable income. They will deduct the monies that have been paid as tertiary education tax before then paying their company's income tax. So the next tax is petroleum profit tax. And like I said, this tax is applicable or is applied on the profit of companies engaged in petroleum operations in Nigeria. Essentially, it's for those that operate within the upstream petroleum industry, the upstream sector of the petroleum industry. This is what they pay in lieu of companies' income tax. So the rates vary I think it's about 50% for petroleum operations under the product sharing contract with the NNPC. It's a graduated scale as well, or different percentages apply. I think there's another one that is 85% for non-production sharing contract after the first 5 years. We'll move to the next one, which is the Police Trust Fund levy. Now, this is actually a levy that is also imposed at the rate of 0.005% of the net profit of companies operating business in Nigeria, which essentially almost covers all companies operating a business within Nigeria. But what we see is that even though this is a provision in an act, it's supported by law, but they've not really started enforcing this provision. So currently there are mechanisms being put in place to enforce the administration of this levy to ensure that people pay. Now, pending when that because we don't know when exactly the tax authorities will start enforcing this, but I just thought to also note that the obligations that companies have in relation to this levy should ideally terminate in sometime in June of 2025, because that's the time that the fund which was set up under this act, that's the Police Trust Fund, is expected to cease from existing, unless if by an act of National Assembly they now extend the period. It's actually not meant to exceed June of 2025. Very quickly, we'll move to the next tax, which is the value-added tax. I'm sure a lot of us are very familiar with this tax. It's a consumption tax, which is essentially placed on a product whenever value is added at every stage of the supply chain. So if it's from production all the way to the point of sale. In every accounting year where an SME expects to attain the threshold of 25 million, you remember that I said 25 million is the threshold for small companies. So if a company knows that it's expected to attain the 25 million threshold, it is expected to register for VAT in that year, and then of course to charge the appropriate rate, which is 7.5%. It was previously 5%, but with the Finance Act, it was increased to 7.5%. Now, if for whatever reason the SME does not register for VAT, penalty can range from 50,000 for the first month. It's usually 50,000 for the first month of default, and then 25,000 for every subsequent month during which the default subsists. So for as long as a company or an SME is supposed to have registered for VAT and it doesn't register, it's accruing liabilities on a monthly basis. So it's important for all SMEs to ensure that they've registered for VAT where applicable, or in the course of an applicable year, to ensure that they've registered. Now, I also wanted to note that if for whatever reason an SME wants to permanently cease to carry on business, and we have some companies, that wind up because maybe the company cannot be rescued or the purpose for which the company was set up has been accomplished, and they want to wind up their operations, there's a requirement for them to notify the FIRS, of the fact that they want to deregister. If they don't notify, tax obligations will continue to accrue because the tax authority will assume that the company is still in operation. So it's important just to make sure that, excuse me, it's important just to make sure that you're not incurring unnecessary tax liabilities. If the entity is being wound up, then a notification should be made to FIRS within 90 days of cessation of business. So what we need to know about withholding tax. Withholding tax in itself is not a tax per se. It's more like an advance tax. It's an indirect tax, which is deducted at source from the payment or income which is due or which is to be made to a contracting party for the services that they have rendered. So even though it's not a direct tax, it's still important because there's an obligation on the person contracting the services to deduct the tax from source and then remit it to the appropriate authority. Because if you're dealing with an individual, then appropriate authority would be the state inland revenue service. But if it's a company, then the appropriate authority would be the federal inland revenue service. It's important to note that sometimes WHT represents the final tax liabilities on certain passive income. That means that even though it's not a direct tax, in some cases, it's the final tax. I'll give an example. You have a non-resident company providing services to a Nigerian company here. Because the non-resident company is a non-resident company, which means that it's not ideally carrying on operations in Nigeria, the tax that it will be liable to is a withholding tax. And in that scenario, it will be a final tax. So it's not a secondary tax or something that after this tax is levied, they will now use to offset maybe future tax liabilities. No, it's a final tax in that scenario. And I also noted that, of course, it's to be remitted to the relevant authority in the currency of the transaction. So if a transaction is consummated in a currency other than the Naira, because the money is expected to be deducted from source, it's expected to have been deducted in the currency with which you are paying the person who has provided the service. So if you're paying a foreigner in US dollars, your WHT on that transaction should be remitted in US dollars. It should not be converted to Naira. It should be deducted, at the same in the same currency of the transaction. The next one is capital gains tax, and this essentially applies where there's a sale of an asset. Either an individual is selling an asset or a company is selling an asset. Now, the types of property to which this capital gain tax will usually apply are called chargeable assets. So you are selling your chargeable assets, which may be physical or non-physical. It can be machinery, it can be building, and it can even be intellectual property, like trademark and patents. When you sell such assets and you realize the profit from it, you're expected to deduct your capital gains tax, which usually is at the rate of 10%, and remit to the appropriate tax authority. I wouldn't spend too much time on this. I think the slide is very clear. I'll try to move as fast as possible because our time is far spent. Of course, the FIRS administers collection of CGT, whilst the state collects and administers for individuals or where you have partnerships. Import duties, this is an indirect tax that is applied on all goods imported into Nigeria. And the office responsible for that, of course, is the Customs Service. The law is there. They have a table, which is the Harmonized Classification Code, that stipulates the rates that are applicable to different types of goods that may be imported into Nigeria. That is very extensive. So I would recommend that each SME that is represented here should get a copy of that code so that they can know how much duties are supposed to be paid on different categories of products that may be imported into Nigeria. So are there existing taxes which are not applicable to SMEs? Of course, the answer is yes. And we'll quickly go on to consider just two of those taxes which are in existence but are not applicable to SMEs. And then we'll also quickly touch on some other taxes which are applicable to SMEs, or maybe not just even taxes, but other obligations that SMEs have, like pension, remittance, and all of that. Would quickly consider both. So there's the NITDA levy. This is actually an income tax payable by certain categories of company that have an annual turnover of at least 100 million. So essentially, you can see that it's applicable to large companies. Sorry, can I just pause and take some water? Please give me a few seconds. All right. So I was talking about the NIPDA levy. It's calculated at 1% of the profit before tax of the companies to which the levy applies. And those are companies who are GSM service providers or telecommunications companies, cyber companies, or internet providers, pension managers and pension-related companies, insurance companies, banking, and other financial institutions. Those are the companies to which this levy relates. Now, there's the NASENI levy, and NASENI is the National Agency for Science and Engineering Infrastructure. Now, there have been some debates in relation to this levy because the NASENI Act actually imposes this levy on commercial companies and firms with income or turnover of 4 million and above in a year, and says that they have an obligation to contribute 0.25% of their turnover to the fund set up under that act. Now, what has happened is that the governing body of NASENI has increased that threshold to 100 million, to bring it in line with the categorization of large companies so that the tax would only be applicable to large companies. However, the reason I said that there have been debates around this levy is because, some legal luminaries have said that based on the provisions of the act, that the governing board does not actually possess the power to change the threshold as laid down by law. But what I can say is that as of today, and I know that also recently, there's been some directive from the presidency, to the Ministry of Finance and all to start enforcing the provisions of this act, particularly as it relates to the levy. What is not clear at this point is whether in enforcing this provision, they would use the 4%, the 4 million turnover as indicated in the act, or they would apply the 100 million threshold. My guess is that they will apply the 100 million threshold, and I don't see that people would challenge it because it's actually more favorable to a lot of companies in the sense that it then takes SMEs completely out of the bracket of companies which are expected to pay this levy. So we'll watch that space and see how that pans out ultimately. Before I go to the next slide, yes, I just thought to also mention a couple of other duties or taxes or levies, which unfortunately are not contained in my slides. I'll just quickly talk about them. So one is stamp duty, and stamp duty is a tax on legal instruments, whether it's written or electronic. Before, it used to be restricted to just written documents, but again, with the Finance Act, it has now been expanded to cover electronic documents as well. So this tax, the Act makes this tax payable on a wide range of documents, and I'll just mention a few. So bank deposits, transfer, loan agreements, sale agreements in relation to land, tenancy agreements, and the likes. Now, the rates can be ad valorem, which means for value, or it can be a flat rate. And the FIRS has issued circulars in relation to applicable rates for different legal instruments. So I would encourage all the SMEs to familiarize themselves with the applicable rates in relation to each of their legal instruments, just so that they ensure that they are paying the appropriate stamp duties in relation to those documents. The second one is pension remittance, like I mentioned. So employers have an obligation to remit pension on behalf of their employees. Of course, the pension remittance will be done into the retirement savings account maintained by the pension fund administrator that is appointed by the employee. Now, from experience, I know that certain organizations make it mandatory for employees to use a particular pension fund administrator. The law actually kicks against that. It gives the employees the opportunity to say, this is the pension fund administrator that I want, that I prefer to use, and employers are expected to respect that position. In terms of the rates, the Pension Reform Act puts it at 10% for the employer and then 8% for the employee. Of course, the Pension Act also recognizes that the parties may, by agreement, increase the threshold from that cumulative 18%. So if you have a generous employer that wants to be paying 15% pension, then it's together with the 8% that the employee is contributing, then that's fine. But what the law criminalizes is having an agreement to pay less than what the law has said should be paid into the pension, into the retirement savings account. Another tax is property tax, and this is subject to state laws, essentially. So different states impose certain taxes and charges or fees for registration of properties. For instance, I'll use Lagos as an example. Under the land use charge law, the property owners are expected to pay what we know as tenement rate. You know, it's something that is expected to be paid by owners of the land to the government in exchange for the right or the lease of that over that land, which the government has given to the landowner. So what are my tax obligations upon commencement of business? I'll quickly just run through this. Of course, registration of the company with FIRS for corporate tax purposes. The process has been a bit more simplified now, because when you incorporate a company at CAC, they have a unified system where you immediately get your tax identification number, and it will be reflected on your certificate of incorporation at CAC. So that takes away the burden of having to go to the tax office for purpose of getting your tax identification number. Of course, do your VAT registration. Then individuals and unincorporated bodies, of course, are expected to do their registrations because of the direct assessment that they would be undertaking and the filings that they will be making. Where the business has employees, you're expected to register with the State Inland Revenue Service of relevant states for payee purposes, and then also registration with the NSITF for NSITF remittances. Where the business has more than 3 employees, the business will be registered or should be registered with the pension, PENCOM, essentially, for purpose of remitting applicable pension on behalf of the employees. Where the business has 5 employees or more, or a turnover of 15 million, it's also required to register with the Industrial Training Fund and be making contributions to that fund as prescribed by law. Now, for companies that are not carrying on businesses, there have been decisions of courts to say that if, for instance, you have a company limited by guarantee, which is not carrying on trade or business, is not set up for purpose of commerce, the courts have held that they are not regulated, or they do not come under the purview of the Industrial Training Fund Act. So they are not liable to make contributions to the fund. Okay, so I'll quickly go through some of the monthly obligations, tax obligations that SMEs have. So in relation to the VAT and the WHT, there's an obligation to file the appropriate returns by the 21st day of the month following the month of transaction. So if you have deducted WHT and your VAT, you're expected to remit same to the appropriate tax authorities on or before 21st day of the next month during which you made that deduction. For payee remittances, you have 10 days, within which to make your remittances. That's after the deduction. You have 10 days within which to make your remittances. For the pension remittances, not later than 7 working days from the date on which the salaries of the employees are paid. Now we'll go to annual tax obligations. Of course, there's an obligation to file an annual return under payee scheme. I mentioned this earlier when I referenced the Form H1, which shows the summary of the income earned. This is required to be filed not later than 31st January of the following year. So it's important that SMEs take note of the applicable timelines just to make sure that they are filing their returns within the timelines prescribed by law to avoid a situation where they are incurring additional liability. Of course, also you're required to file your annual company income tax. And this is required to be filed no later than 6 months from the financial year end of the company. So I'll give an example. If your company has adopted December 31st as its financial year end, then you're expected to file your company income tax no later than June 30th of the next year. So no later than 6 months. And if it's 30th of September, then you have until the end of March to file your income tax returns. How do I ensure I do not pay or incur excessive tax liabilities? These are just some suggestions to help with managing the tax exposure. So ensure you file your returns and settle tax liabilities as at when due, so that you don't incur penalties or interest for non-compliance. Ensure proper description of transactions so that you don't have a situation where you have paid taxes but they are not properly recognized, and so the tax authorities are still coming after you for certain outstanding taxes. Ensure you include VAT on all transactions which are on which you're supposed to charge VAT. And this is important because if you don't include it, and you're paid for it, you will still have an obligation to pay the applicable VAT, even though the person to whom you have provided the services and to whom ideally you should have transferred the burden of the VAT has not paid, then it means that you will have to still pay for it. The same thing for WHT. If you're supposed to withhold and you don't withhold, there are penalties for that, and then you still be liable to pay the applicable rate for the WHT in relation to that transaction. Another one is setting up your business in a free trade zone, like I mentioned earlier. Of course, it's important you engage someone who has competencies in tax and who understands the tax regime, so that you can get appropriate advice on how you can maximize your tax options. You can have your tax planning. You can adopt or deploy strategies that will ensure that you have minimal tax exposure. These are other tips of how you can minimize your exposure, and then certain incentives or reliefs that are also available. So there's a capital allowance of 95% in the first year in respect of plants and machineries purchased to replace old ones, because of course they are needed for the operation of the business. Then SMEs can also apply for pioneer status where they qualify, for that pioneer status, so that they can enjoy some tax holiday. Then SMEs in the agricultural sector, power, gas, health, textile, can also apply for import duty waiver when importing equipment for their business objectives. Small companies, like I mentioned, of course, are exempted from paying CIT. Companies engaged in agricultural trade or businesses are not liable to minimum tax. Minimum tax is 1%. Medium-sized companies, of course, they are paying CIT at a reduced rate, so that's also good. Then we'll talk about the benefits from tax compliance. Of course, it gives the company good reputation. It also serves to attract investors to your company because it shows that you are a responsible corporate citizen, you're paying your taxes. It also reduces costs. There are a lot of additional costs that companies incur on penalties and interest, stemming from the fact that they're not paying their taxes as and when due. So it's important to ensure that all relevant taxes are paid as and when due to avoid incurring additional liabilities. Then also, of course, and I think Eustace mentioned this, it also helps you qualify for certain contracts. There are certain contracts you cannot get without showing evidence of your tax clearance certificate, which shows that you have paid all applicable taxes. Now, what are the implications for non-compliance? It's obvious. I've spoken a bit about this. If you don't pay your taxes as at when due, then you have penalties, you have sanctions, which may include fines, interest on unremitted taxes, and even imprisonment in certain cases, where an SME is convicted of default. Then, imprisonment may be enforced against the entity and the directors of the entity. Before I move to this last slide, I would just like to close by saying that whilst it may appear you know, that there are a lot of taxes which are applicable to SMEs, and it imposes a lot of obligations and all of that. With the help of a professional who can assist with deploying tax planning strategies, you can achieve better efficiency and compliance with your tax obligations under law. In some cases, you would even find that you don't even need to pay any additional taxes. Maybe the taxes you have been paying are sufficient, or the amount that you have been paying in taxes are sufficient to cover your tax obligations. In some cases, you may even realize that you are entitled to refund. You know, maybe you have overpaid certain taxes. That's why it's important to get professional advice, you know, and have those who have the competencies look at your books and see how you can deploy tax planning to minimize your tax exposure. Of course, importance of compliance cannot be overemphasized. You know, I've spoken about the advantages of compliance. And once you are compliant with your tax obligations, you can then focus your energy on scaling your business. You know, that way your business will not only be free from any negative regulatory sanctions, penalties, and what have you, but then you would also be a responsible corporate citizen, and you would also be able to reap the benefits of being fully compliant from a tax perspective. Thank you so much for listening. If there are questions, I don't know if the questions will be taken at the end of all the sessions, but if you have questions, then we can take the questions now. Thank you.
Thank you so much, Teresi. So the next segment is intellectual property law for SMEs. Let me try to share my screen. Okay. Sorry, I'm having some trouble. Okay, I definitely have shared the wrong thing. I'm so sorry. 1 second. I'm having trouble getting it from there. Let me try this instead. Gosh. Sorry, I keep pressing the wrong thing. You know what, let me just start while I'm battling with the screen. It's taking too long. Okay, so Sorry, 1 minute. Okay, so can everybody hear me?
Yes, we can.
Okay. While I'm trying to sort the screen out. So IP can be protected under Nigerian laws, and so starting with what intellectual property is, according to the World Intellectual Property Organization, intellectual property is a creation of the mind, such as inventions, literary and artistic works, symbols, names, images, which have commercial value. And it is a category of property that is intangible, and it's a product of intellect. And it can be primarily divided into copyrights, patents, and trademarks. So the types of works that can be protected in Nigeria, like I said earlier, include copyright, trademarks, patents, trade secrets, and industrial designs. So copyrights cover things like, paintings, artwork, poetry, plays, sculpture, sound recordings, motion picture, and trademarks cover things like slogans, symbols that identify goods and services in the marketplace. So for example, Coca-Cola is a registered trademark of the Nigerian bottling company. Patents, which cover all inventions and demonstrate technological development and progress. Trade secrets cover confidential information which belong to a business and give the business a competitive advantage. So why do we need to protect intellectual property? Why do SMEs need to protect their intellectual property? The reason is that, for example, your IP gives you an edge over other businesses. Sometimes your intellectual property is what differentiates you from another brand and another business. And, protecting it is important to avoid intellectual property theft and copyright infringement and things of the sort. How can intellectual property rights be protected in Nigeria? So the laws that are, covering that are sort of that cover intellectual property rights, there are various laws, and one of them is the Copyright Act. Another, sorry, 1 second. Okay, yes. So the Copyright Act, Patent and Design Act, Trademarks Act, the Merchandise Marks Act, and Trade Malpractices Act. So under, the benefits of, okay, we already talked about the benefits of protecting your intellectual property. product differentiation, brand recognition, and technological advantages. Also gives your business an advantage, over other brands. So how long does your protection last for? The number of years? Because when you protect your copyright, it's not perpetual. It doesn't last forever. So under copyrights, the duration of a protected copyright depends on the type of work generally. So for literary, musical, artistic works other than photographs, the copyright subsists from the date of creation and expires 70 years after the end of the year in which the author dies. In the case of a sound recording, films, photographs, copyright expires 50 years after the end of the year in which the first publication was made. Whilst for broadcasts, copyright expires 50 years after the end of the year in which the broadcast first took place. Trademarks are generally valid for a period of 7 years from the date of the initial application. It is, however, subject to renewal from time to time at the option of the registered proprietor, and each renewal is valid for a period of 14 years from the date of expiration of the original registration. And there's no limit to the number of renewals a mark can be subject to. So as your trademark runs out, you can continue to renew. Patent. So for patents, a registered patent is valid for a period of 20 years and is subject to an annual renewal and payment for the renewal fees, which after you pay the renewal fees, after the 20 years, the patent reverts back to public domain. And where there is a default in the payment of the annual fee, the patent lapses. And if it isn't renewed after the expiration of 6 months of grace, the patent may not be revived. And so you can lose your patent if you don't pay your annual fees and the 6 months of grace has expired. Under designs, once a design is registered, it is renewable, and the registration of a design lasts for a period of 15 years, after which it reverts to the public domain and is no longer renewable. However, the design must be renewed after every 5 years within the indicated 15-year period. So how you can, enforce your intellectual property rights. There are different ways of enforcing your intellectual property rights. Obviously, going to court is one way, but it's important to note that there are certain rights that for you to be able to claim them, you have to have, some IP rights you don't have to register to be able to claim, but some you have to. So copyrights, for example, once that work has been created, your copyright, starts from when you create the work. Your copyright exists from the moment the work is created, and you do not have to register your copyright to be able to claim, copyright infringement if it does happen. But it's important to note that registering your copyright is probably advisable, because when your copyright is registered, it is easy for you to prove that, it's easy to prove ownership. It's easy to prove that that copyright, you were the, first person to own it. So registration of copyright makes proof easy, though it is not required, but it is usually an easy way to prove your copyright. For trademarks, you need to register your trademark to be able to prove, to be able to sue for trademark infringement. If your trademark is not registered, you will not be able to, go to court to sue for trademark infringement. And another way to resolve, infringement is via alternative dispute resolution. So mediation, arbitration as well is one way that, such matters can be resolved. As we know, matters in court can take, a really long time to resolve, with adjournments and stuff like that. And so sometimes, ADR might be a preferred option, though it's not always affordable for all parties. Not all parties can afford, arbitration, but, it's a faster option if parties can afford it. And there's some regulatory bodies as well that help in the enforcement of, intellectual property rights. For example, there's there are some bodies that help people in the arts, especially musicians, help them with copyright matters, people in, in film and music, piracy bodies, and also so once you have been able to use ADR, or turn to a regulatory body, or use the court system, those are sort of your options in resolving copyright infringement. It's always important when you're setting up, your business, to speak to a lawyer about copyrights, because there's certain, it can save you a lot of costs. There's some unnecessary costs that, that you can save yourself from when you have your copyrights protected. And, it's also important to avoid infringing on the rights of other bodies and other businesses as well, because litigation can cost you a lot of money. You can get sued, and it can cost you a lot of money, and it can be really bad publicity for your business as well. And things can really just go really bad in a very short while if you don't do your research before before taking certain steps. And that is why protecting your intellectual property is important. And before I go, I wanted to, give an example of an IP matter that, well, two examples of IP matters that I think you might have heard about in the news. So one is a local, by local I mean a Nigerian matter, and the other one is an international matter. So the first one is the Wizkid and Wizkid incident. You might have seen that on the news. So there's an artist that has been going by the name Wizkid, but he not only has been going by Wizkid, he has also been naming his songs. He named his songs after Wizkid's music, and he also used the same song names, album names, and he did that so that he could benefit from Wizkid's in intellectual property we call it goodwill. So obviously Wizkid is a very popular artist, and he's well known, and his brand is, he has a very big brand. And this artist who is not as known, thought it would be a clever idea to benefit from the streams. And so people were accidentally downloading, this artist's songs, thinking they were downloading Wizkid's music. And obviously you've already paid for it, and it's not something you can exactly return. And so obviously it was discovered that he was doing that. And the music platforms, took his music off the platforms, and Wizkid's record label is also taking legal action against him. And whatever benefit he thought he was getting from that, because sometimes people think that, oh, I have a small business and nobody is going to find out what I'm doing. But the world is a global village now, and you never know who is going to see what you have done. And so sometimes even little things like using someone's work without giving credit. So sometimes it might not be a blatant stealing of someone's work, like in this Wizkid example, but it could be using work without giving credit. It could be showing someone's brand in your video. Say for example you're a content creator, and you accidentally show a brand in your video, or you use someone's music without permission. Those seem like little harmless things, but you can potentially be looking at a lawsuit. Or if you are if you sell a product and you use another brand's packaging, there's some things that seem harmless and seem like something so small, but at the end of the day it can be a real big problem for the party involved. The other case I wanted to use as an example is the Nike and Mischief matter. Some of you may have seen this, and some of you may not have seen it, but the artist Lil Nas X, he, as part of promotion for his his latest video, he worked with an art collective to make these, he called them Satan trainers. So they used Nike trainers to make these Satan trainers. And so the Nike, tick was still showing. It was very recognizable that they were using Nike Air 97s. Like anyone who saw the trainers knew that they were very recognizably Nike trainers. And they sort of made some slight alterations on the trainers and they put them on the market. Their argument was that it was art and that art is, covered by freedom of expression. And so, and obviously, everyone knew that they were not trying to, use the Nike brand or take over, Nike's customer base. People know that they're artists and they usually make products like that. But the court ruled that it was trademark infringement. Not only was it trademark infringement, it cost Nike, some problems because some Nike customers were not happy because they thought Nike was involved in making the trainers, and some people were even deciding to boycott Nike. And so eventually the trainers had to be they had to suspend making the trainers, and the court, and they have now, as part of the settlement of the matter, initially they were in court, but I think the parties worked out that it would be quicker to resolve it out of court. And so they decided that they would resolve the matter out of court. And so they have now agreed to pull the shoes from circulation. And I saw on the news today that the song has also been affected. It might be related to the lawsuit as well, or something else may have happened there. But it's really important to be careful about trademark infringement. Be careful about basically be careful about intellectual property that that it's not, that did not originate from you, because you never know what sort of lawsuit you might be looking at. And I think that sort of covers everything. Obviously, intellectual property is such a vast area. I could never go through everything in the short time that we have, but I think I've sort of touched on the most important parts. Thank you for your time. If anybody has any questions now, let's try and take some questions. I'm so sorry about this screen situation. This is a new phone, so, oh God. This is a new phone. I'm still learning my way around it. Okay, so do we have any questions? I think I saw a few questions earlier. Okay, let me just read them. Have they been answered?
Hi, Falakemi. I mean, I've been trying to answer some. I don't know if any of the other speakers want to take. I answered one privately.
Okay.
And I answered two other ones. So I don't know if any of the speakers want to take any of the questions there.
Okay, let me just answer some of the ones I can see. How difficult is it to patent ideas in Nigeria, and would the patents just cover Nigeria? Okay, so the patents would only cover Nigeria. So let me answer that part first. How difficult is it to patent ideas? I think the first thing is, what are you patenting? Because the whole point of patents is that it's usually something tangible. So it's maybe the model for like a bottle, for example. Sorry, let me just let me just show you my camera so you can see what I'm trying to say. It can be, yeah, so for example, this bottle, your patent might be maybe for the cover of this bottle or for this portion of this bottle. An idea in itself that isn't sort of, that has not been, so it could be an idea. For example, now this is an idea in itself, meaning that it's a cap for bottles, but if it had not been sort of executed to this point, then you can't patent it. So if it's just still an idea in your head, then you can't exactly patent it. I hope that makes sense. But once you have sort of the product of what you're trying to patent, it's not, it's not difficult to patent. Are there legal protections for small companies who might have to cover due to fear of legal fees? Larger companies sometimes bully companies by with lawsuits. Are there protections? I mean, to be honest, it really depends on what the situation is. It depends on the reason for the lawsuit. So if the smaller company has nothing to worry about, so if they have not sort of, broken any laws, or they haven't done anything that they need to worry about, then it doesn't matter, if someone is trying to, flex their muscles and go to court. But where you have, sort of done something wrong and you have something to worry about, then, the best thing is always to try and resolve the matter out of court, if you can, to avoid having to pay for a lawyer and, having to be in court. But sometimes, to answer your questions about, are there protections? I wouldn't quite say protection per se, but, there are ways of resolving matters. For example, there's there's the Lagos Multi-Door Courthouse. You can resolve matters there by mediation, arbitration, and there's also sorry, what's this public Office of the Public Defender. Yeah, so some people resolve their disputes there as well. The Office of the Public Defender, and that's usually pro bono, work, and they don't charge you for their services. And the truth is, there's some lawyers that will not be as expensive and would sort of help you resolve these matters. I've always been confused. Is it better to register a business or incorporate a company? It depends on what you're, doing, using the business for. If you register a business name, there are a few limitations, and compared to if you, register a limited company. So, for example, when you register a business name, if you want to sign a contract, you have to sign the contract as, yourself, as a person, rather than using the business name, because the business name is not a legal entity, but a limited company is a legal entity, and you can, sign a contract when it is a limited company. So, those are some of the differences. I mean, if you're just starting out your business and you're not sure what direction it's going yet, and you're not, you've not sort of decided, you just want to see how it is going to go, it's okay to start with a business name and then proceed from there as things get, bigger and better. recently one of our celebrities trademarked her name. Why should she have the only right to use the name that several million other people have? Well, that's a fair question, but when someone has, sort of worked on a brand and the brand has now become, associated with them, they have a right to trademark, that name. I mean, for example, Coca-Cola trademarked Coke. There are many other meanings for Coke. Coke, for example, means cocaine, but, Coca-Cola chose Coke as, they chose to trademark the name. So sometimes a brand, even if it's, something that other people can use or would have liked to use, a brand can trademark a name. And because once you trademark your name, you put in a lot of work into advertising that name, into making that brand recognizable, into making it a brand that people come to love and respect. And that's a lot of effort, and that costs a lot of money, and that isn't something that everybody should have access to. I hope that answers your question. To follow up my question, you know how sometimes people collide with you on the road, even if they're in the wrong, and the basic tactic is to start shouting, to blame the other person rather than admit wrong. In the same way, some businesses just start threatening you when you've legally done nothing wrong, just because they view your operation as a threat. I think I sort of answered this question already. Yeah, this is Uche's question. I, like I said, when you've done nothing wrong, sometimes they would, make a fuss, threaten you. You can choose to settle out of court if you feel like you cannot afford the, if you feel like you cannot afford the drama and the cost of going to court. But also, you can decide to go to court and watch it play out. Going to court sometimes takes time and it's pointless. So if you can, resolve it via, alternative dispute resolution, or by even just sitting across the table from them and finding out what they want, sometimes that can be helpful as well. But unfortunately, sometimes, someone having more money or a more known name than you, sometimes they try to bully you. But I always say that there will always be a lawyer who knows their stuff that will not cost you as much as maybe an SAN will cost. And they will always be willing to help you. I know people sometimes have the wrong impression that lawyers are expensive, but there's always someone that you can afford. You just need to find them and hire them. Does anybody have any more questions, or are we good? Does anybody want to add anything? Does any of the speakers want to add anything? Okay, well, I think that's it.
No additional. Sorry, Falake, it appears that you're still on mute.
Sorry about that. I was saying I think I can see another question. Oh no, it's not a question, it's just a full stop. I was saying, does anyone else want to add anything? Chelsea, did you want to add something?
No, so I was just confirming that no additional comments from me. I think you've satisfactorily answered all the questions, particularly the one in relation to whether to set up a business name or an incorporated company.
Yeah. Okay, well, I think we're done.
Oh, sorry, Falakim. I think we have a question. Recently, one of our celebrities trademarked her name. Have you answered that?
Yes, I have. I have. Yes, I have. I have. Anything else? Just trying to tell them that we're done. Already closed the session. Yeah, we've closed the session and we've answered the questions.